Okay, folks, I'm attorney Nate Amendola, and today we're going to talk about what happens at a clerk magistrate's hearing. Before we talk about that, you should know a little bit about the way people get charged with crimes. In general, you're either arrested or sent something called a summons. And the summons is a piece of paper that requires you to come into court. Okay? So, if you've been arrested, the police still need to do something with the court in order to actually formally and officially charge you with a crime. There is a process, and it's called an application for criminal complaint. So what happens is that the police go to the court and they fill out this application for criminal complaint to charge you with something. They attach a statement of facts or a police report to the back of the application, and then a clerk magistrate reviews the application for one thing and one thing only, and that's called probable cause. The clerk is determining if there is sufficient probable cause to charge you with a crime. And most of the time there is, because probable cause is a very low standard. If the clerk approves the application, you will move forward towards an arraignment. Now, there are lots of situations, however, when the police still want to charge somebody for a crime, but that person has not been arrested. Let's consider the following example. Police respond to a single car accident. When they get there, they suspect drunk driving because there's a few empty beer cans on the floor. They're talking to the driver, and the driver's got the smell of alcohol in his breath, red, glassy, bloodshot eyes. However, the driver needs to be sent to the hospital for minor injuries. Now here, you can imagine arrest isn't appropriate. So in cases like this, the police still want to charge this person for something, but they haven't arrested him. So what they'll do is they will still fill out an application for criminal complaint to determine if there's probable cause, and they'll send that to the clerk. The clerk, however, will hold something called a hearing, a clerk magistrate's hearing. Sometimes you might hear it called a show cause hearing or a clerk's hearing. The thing about these hearings is you have a right to be there, and you have a right to bring an attorney with you. The attorney can question the police and present evidence on your behalf. Now, you must remember that the purpose of this hearing is not to determine guilt or innocence. That comes later at trial. The purpose of this hearing is only to determine whether there is sufficient probable cause to charge you with the crime that you were not arrested for. Now remember, probable cause is a low standard. It's the same standard that the police have in the field to make an arrest. If the magistrate finds probable cause, the magistrate has two choices. They can issue the complaint, which will result in formal charges against you, or the magistrate can defer a decision on the complaint subject to some conditions, perhaps imposed on the accused. This is sort of like a double secret probation. Now, the magistrate can only do that if both the police and the accused agree. If a decision is deferred and the conditions are met, maybe like defer the decision for 6 months subject to alcohol treatment, oftentimes the complaint will be dismissed and the charges will not issue. Okay? You can and absolutely should bring an attorney with you to a clerk's hearing. This is a great first bite at the apple and a way to thwart criminal charges.